Good afternoon, everyone.
Hi, good afternoon.
Hi everyone, I'm Bhavini Kalaria. This is
Kishan Bhatt.
And I am Khaled Mueed.
So welcome everyone. Slightly different format this time round, as really looking forward to the second episode. If you caught us the last time, we were talking about lots of different issues, Brexit, so on and so forth. So Khaled has joined us, so we're going to be covering arbitration. I think last time we just started off with kind of what was going on, and one of the things that occurred to me was, and this was before we'd even started, was when we were planning this thing that, we're in the middle of an election now.
I know. Can you believe that? I cannot believe that.
Just over 2 weeks to go.
2 weeks to go.
2 weeks to go. Episode 1, we were talking about Brexit. Episode 2, we were talking about election.
We weren't even contemplating it.
Major events.
Major events. And the thing about this thing, Khaled, is that what we wanted to do was kind of talk about the stuff that's happening.
Yeah.
And kind of tie it into what's happening with people. And one of the things that I noticed was there's a lot of information, there's a lot of stuff out there about fake news, how are people going about, whether it's during an election campaign or otherwise, getting information out there. So there was something just recently that I was reading about how are companies allowed to target consumers, individuals, the electorate, whoever it might be. How is that regulated? It's quite an interesting
So
topic.
this is an area of data protection, and I've also seen something in the papers where we've got GDPR, that's the General Data Protection Regulation, which is coming into force tomorrow, and that will completely change the way consumers' data is collected. And it's European regulation, but it will still have force in the UK after Brexit. And consumers will actually be able to ask how the data is collected and what it's being used for, and they'll be able to ask companies to show them what personal data is being gathered.
Yeah.
And we know how easy it is whenever we are, filling in a form online, and there's usually a tick box, tick this box if you want to opt into receiving, or untick if you don't want to, and it can be very confusing.
Yeah.
But what tends to happen is people, knowingly or unknowingly, are ending up on lots of databases, and mail shots being sent out, charities, they sending out mail shots to lots and lots of people. And we had that awful case, I don't know if you remember, a few years ago, this old woman who had received...
She
She
got so many calls,
Absolutely.
Same person as well.
Indeed, yes.
Well, I think, do you know what, it'd be good to kind of find out what you think about how that's going to impact, whether it's the businesses. We work with a lot of business clients, as you know. Businesses, people... I know that there's been a lot of press around the kinds of fines people are getting, because the fines under this legislation are it's like 2 to 4% of your turnover. It's something fairly high. It's not. So, what do you think the impact is going to be?
I think it's going to be massive. I think talking about fines, and it's an interesting topic. We all hate spam. We all hate text messages we don't want. So recently, a company called OneCom Limited was fined £100,000 for sending millions of spam texts about mobile phone upgrades, and that was an investigation done by the ICO.
And TalkTalk last year, they were fined £400,000 for their security failings and data breach.
So do you think that's an enough amount, though? I think that's a very small sum for a big company like that, like TalkTalk, for example, to pay only £100,000 for sending 3.3 million text messages out randomly. Do you think that's a deterrent? Do you think it will deter companies like that?
Well, it's more the publicity, isn't it?
Yeah.
It's getting bad press for a company, and the reputational damage. Fair. That compensation, where does it go to? It doesn't go to the individual consumers.
No, that's a good point. I think there is. I actually don't think. I agree with you. I think it's the reputational damage, and bearing in mind that really nowadays the data that you're holding is the thing that really gives you your value. All these platforms that we use all the time, they use our information. And so I think this is part of that drive to kind of take back a little bit of control over the ownership over the information.
Even, I mean, because we're in the election season, even like if you're on the electoral register, there is the open register which anyone can have access to, and then you can opt out of being on that, the open register, so that your details are not. So there isn't a lot of awareness.
Yeah.
I know there's been a massive drive to get a lot of people signed up, to register to vote. So these are the sorts of information that's not often out there, for people. And then you kind of wonder, how did my details end up where it ended up?
Yeah, it's interesting. I do question how easy it is to implement things like that, because I do often get calls randomly, sales calls, and as soon as you say that take me off your database, they just hang up. And I don't know if you guys get the same thing.
No.
So I don't.
I'm sure that there must be a procedure in place. Like for big companies, they must have procedures in place. If someone says we don't want to have.
Yeah, I often get a call about the car accident.
Yes. PPI.
And then I'm like, I have not had a car accident. But and I wonder, maybe the trauma of the car accident was so much that maybe I've forgotten about it.
But you know what I think more than that, I think the other reason why this kind of stuff is important is because it kind of ties in with the stuff we were talking about last time on Brexit, because there's the data protection regulations that are coming in. They're European in origin. The government has said we're going to be taking them into we're going to be basically uplifting them and putting them into our own legislation. So, companies here, I think it's going to apply to American companies.
Mm-hmm.
They're still going to be bound by it. And I think it comes on to some of the other issues that we kind of wanted to talk about, which were around the role of the UK courts.
Yes.
I mean, it's such a big thing now. I mean, if you read some of the legal press, they're talking about... and I don't know what you think about this, because it kind of ties in with the international element of your practice. But commentators are talking about people trying to come out of contracts because of Brexit. How does that impact on the way courts are going to be used here? Jurisdiction-wise, is that going to have an impact on the UK later on? Do we need to have legislation that is still very similar to the kinds of legislation we've been used to in the past? So, I mean, I don't know if you've had any... Have you seen anything that has kind of caught your eye about that, or got any thoughts on kind of the impact on UK courts?
Well, I think maybe I ought to just do a quick introduction of myself. I've recently joined London Law Practice, and the area that I specialise in is arbitration. And arbitration is something that always arises out of contractual disputes.
Mm-hmm.
And so it's interesting that you mention where there are contracts and Brexit, how will that impact? Will people try and get out of their contractual obligations? But we know that there is force majeure, but I don't know if this is something that quite amounts to force majeure. I mean, how that would actually fundamentally change the contractual obligations. Brexit is just one of those things. But in terms of arbitration, which is what we increasingly see counterparties between different jurisdictions, they opt for arbitration more so than litigation. Because with arbitration, if there are two parties from two different jurisdictions entering into a contract, you wouldn't want to end up in the local court of either party's jurisdiction.
So it might be a good thing for people watching to know what the difference is between litigation and arbitration. I think hopefully most people know litigation is kind of when you end up in court, and the kind of typical stuff that you see when you envisage a kind of a court matter dispute ending up. So how is that different from arbitration?
So arbitration is more common, as I was saying, between multi-jurisdictional, cross-border parties. So you might have an Indian counterparty. It's actually an arbitration so I'll use that as an example that I worked on at my last firm. So you have an Indian counterparty and a Middle Eastern counterparty. And now in the event of a dispute, so the Middle Eastern party wouldn't want to end up in Indian courts, and for the Indian party, they wouldn't want to end up in the Middle Eastern courts. So arbitration that gives you the flexibility, which it's private, which means that it's confidential, and it's a process where the parties have complete control over. And often you would have 3 arbitrators, which are 2 of whom are chosen by each counterparty. So you have 2 parties who are in dispute. Party A will appoint an arbitrator, and Party B will appoint another arbitrator, and the 2 arbitrators will then appoint somebody to be the chair. So you have a 3-member panel. But you can also have a sole arbitrator.
It sounds very expensive. You know, like if people are, I mean, just from an interest point of view, when you're talking about having 3 different people involved on a panel.
Well, the thing is, recently arbitration has, in the very big cases, has become rather expensive. But one of the features of arbitration is that it's meant to be less expensive.
Yeah.
It's meant to be quicker than going through litigation in the courts. But if it doesn't always have to be very expensive. But I think the key thing where you have in the big disputes between big corporations is the fact that it gives them complete confidentiality. So if the 2 parties, there is a dispute, but despite the dispute, they actually want to continue working because they have maybe other contracts in place. And the last thing they want is all of this stuff to end up in the press and for people to be talking about it, that X has fallen out with Y, which is why you may choose arbitration. It's private, it's confidential, and whatever it is dealt with. And arbitrators, the panel will issue an award, which is then enforced. And it's final and it's binding. So unlike litigation, you might have appeal rights to go to, Court of Appeal, and then that can be appealed further on to the Supreme Court. But with arbitration, parties, they agree to it. They have an arbitration clause in their contract, and they know that whatever the award is final and binding.
So when I mean, it might be good to see if people are actually asking questions, but when someone is drafting a contract, and I mean, one of the things that's kind of interesting from, because I'm a litigator, but we also draft a lot of contracts within the firm. So, and when we see that, quite often the way that I kind of see the trend in litigation is people are concerned about funding, particularly the kind of clients we're looking at. And so we're often saying, look, have an arbitration clause, have a kind of ADR type clause in your contract. So the way that we're drafting the contracts is now changing. How would you say, if you are a smaller business, would something like arbitration be helpful to you? And I know that London Chamber has just recently started a service. I know that because of the cost of litigation, people are looking at alternative ways of resolving disputes. Is it helpful? I mean, do you have
absolutely.
it in your contracts?
Arbitration clause is obviously something that both parties would have to agree to from the outset, and it will set out the thing with arbitration. How it's different from litigation is you have complete control over the procedure, how you want to run the arbitration. And, parties will often sit down with, if there is a 3-member panel, the arbitrators, or if there is a sole arbitrator, and they'll just discuss, when the steps will be, if they need to, how many rounds of submissions, written submissions the parties have to put in, and when they want to have the hearing. And with litigation, you don't have control over that. You mentioned the London Chamber of Arbitration. Historically, they used to refer their members onto other arbitral bodies. So you have in London, you have the London Court of International Arbitration. In Paris, you have the International Court of ICC, International Chamber of Commerce. And then you've got SIAC, which is in Singapore International Arbitration Centre. So with these arbitral bodies, in the arbitration clause, you'll say that the parties will resolve their dispute through arbitration using the rules of X body. So it could be the one in London. And there is also the seat of arbitration where the arbitration is going to be held. So if it is held in London, for example, as the seat of arbitration, it means that the procedural law of arbitration will be governed by English law. So for example, if parties want to challenge the award because there have been, some impropriety, then they can challenge it in the courts. So for small businesses, it could work out really well, and it gives them a lot more certainty about a lot more control, and also gives them the confidentiality aspect. So especially if they don't want to end up in the press because there's been a dispute. That's why it's good to choose arbitration.
Yeah.
Well, look, if anyone watching, if you've got questions on how to draft your contracts, what kind of clauses you want to have in them, how arbitration could work from you, then just please ask us your questions, and Khalid is here and more than willing, I'm sure, to talk about this area. I think also coming on from that, I don't know, Kishan, whether you've got some thoughts on this.
You wanted to talk about mediation, because that's also another area.
Another
area to resolve.
So this is all about how to creatively resolve your dispute, and that's what we're talking about here.
Absolutely.
And in ways where you don't have to go to court, you don't have to spend as much money or go through all that stress, and like Khalid rightly said, be in the public light about the whole dispute. So I'm an accredited mediator. It's slightly different to arbitration. Arbitration is a little bit more formal. With mediation, it does suit certain circumstances, and of course we can assess on a case-by-case basis what the right circumstances are for either applying mediation or arbitration. But mediation is very simple. Essentially, you normally appoint a mediator, such as myself, who will resolve a dispute between two parties. What you normally have is a format where you will send a position statement before the mediation starts, so you know what the position is of one party, you know what the position is of another party.
And would you appoint lawyers to draft that, or would the parties draft their position statement?
It entirely depends. If the parties want to appoint lawyers, then the lawyers can certainly draft the position statement. If the parties just feel like they just want to appoint a mediator, then that's okay as well. And it's almost like a witness statement. It's your position on the dispute, where you stand on things, what you want from the mediation, and it's trying to find creative ways to resolve a dispute. And it's worked quite well in the past, from my experience. So normally,
do you need to have a mediation clause in the contract, or can they choose mediation?
You can just choose mediation. You don't have to have a contractual clause. They're becoming more common these days.
Can I just interrupt? Let us know if you can actually see us, and whether we're still going live, because I don't know if it's frozen, the screen.
Are we getting any comments?
Yeah, this is the thing.
We're gonna have a quick check
to see what's going on.
Yeah,
see what's going
on. Some tech issues.
There's your questions. I think that we might have
timed out.
Yeah, I don't know if about timed out.
No, we're still on, according to this.
Yeah, let us know if it's still live.
Yeah, let us know if it's still live. If it's still running.
All is okay.
All is okay. Great.
Yeah, great.
Thank
Good
you.
To hear. Okay, so let's go back to mediation. So the format of mediation is very simple. So you essentially have 3 rooms: one room for a mediator, and 2 separate rooms usually for 2 other parties. Although it's very flexible, you can do it in various different ways, and there's various strategies around it. But normally this is the normal traditional setup, and the mediator will go between each room. They'll go to one room and find out what the parties have to say about their case, and then go to another room and find out what that party has to say about their case. And the mediator will do his or her best to try and bring forward a binding settlement between the parties, which they can then sign, and that's essentially signing a contract and agreeing on what how to resolve this dispute. And it can be quite flexible, it can be quite creative. I've had cases where we've had commercial parties continuing business, and that's the beauty of it. You have commercial parties that are rowing over each other over, could be money, or it could be things not being done correctly or negligently, and then it's trying to find a creative solution around it. And I think that's the important thing here.
I think with these forms of dispute resolution, with mediation, arbitration, the biggest advantage is that where parties actually want to continue to do business with each other.
Yeah.
And this is just making sure that they quickly resolve whatever dispute they have, and whatever is owed from one party to the other, and that's settled in the quickest way possible.
Yeah, it's commercial solutions. Yeah,
absolutely.
I mean, I think that what's also interesting is that there's a lot of conversation around different ways of resolving a problem.
Yeah.
But the UK still remains kind of a really good place for just resolving your court case, resolving your dispute in the courts. I mean, I don't know whether you've got any thoughts on why that might be, but I know certainly, as well as being a centre for arbitration and mediation, some of these other things, we still remain a really good place for businesses to come and resolve their disputes. Quite often we see that because of the contracts, the common law basis on which our contracts are drafted, basically, the settled law, all of these things are effective.
I think English law is obviously a big pull, because especially in a contract law you have certainty of that decisions have been given and there is a consistent precedent-based system, which you perhaps don't have in civil jurisdictions. No. So I think it's the certainty if you have a contractual dispute, which is why we have seen so many big-ticket Russian disputes end up in English courts. But I think going back to the alternative means of dispute resolution, so we've covered mediation, we've covered arbitration. There's also negotiation.
Yeah, of course. Yeah.
That parties, should never kind of
shy away from.
Shy away from.
It's always
negotiation.
Good to talk.
Yeah, and then often you have in construction disputes you have expert determination.
Meeting.
Expert determination where you bring in an expert to similar to arbitration. Similar to mediation actually, but in this case you have the expert, whereas in mediation the role of the mediator is like an umpire.
Yes.
Almost. So the mediator doesn't get involved in the dispute itself. The role of the mediator is to get the two parties to discuss, to talk, and to find a solution. Whereas expert determination is where you're putting forward your respective positions, that the two parties and the expert will give a verdict.
So do you think... So, this is how I would see it. If I was a business person and I was kind of faced with, I need to have a contract with, say, a foreign country. So we had someone came to us and said, we've got a party in, I think it was in Singapore. How do we go about drafting this? And by and large, we obviously advise our clients to say, draft them in English law. It makes it easier for you from a dispute resolution point of view. Yeah. But, how would you go about explaining to someone, just, people who are watching, what the best method to include in your contracts is? We would, by and large, have some kind of alternative dispute resolution, have a place where you would like to have your matter resolved. But is there any kind of things that you've come across with clients you've worked with in the past, like real life examples?
You could actually, in your contract at the start, you could actually appoint an expert. Have an organisation to determine if there's a dispute. So, for example, construction. I know with construction contracts, you always want someone who's RICS qualified, so someone who's regulated with RICS, a chartered surveyor, to determine that dispute. So you can predetermine that. So that's certainly possible.
Bizade's asked a question.
Oh yes, Bizade.
Okay, so he says, what can be done to recover money if an arbitration award is made and the other party does not pay? That's a question for you.
Okay. So to recover money if an arbitration award is made and the other party does not pay. So I think the question is what are steps they can take to whatever the award has been given. Now, arbitration works because there are jurisdictions, they are party to the New York Convention, and most jurisdictions around the world are signatories to the New York Convention. It's a 1958 convention which says that if there is an award, enforceable award, then that jurisdiction, so if, for instance, an award has been given against, let's use an example, an Australian counterparty, and Australia is signatory to the New York Convention, and you're trying to enforce an award in Australia, Australian courts, you'd go to the courts and say that we have an award against a party in your jurisdiction, and the courts should then ratify that. Should say yes.
Do you think it's easier Is it easier than enforcing a court judgment, where you have to kind of get it recognised?
In theory, arbitration awards where the parties are signatories to the New York Convention should be easy enough to enforce. But however, it doesn't mean that there are rogue parties who will not want to pay up.
So would then enforcement be in the same way? This is for anyone who's not a lawyer, may not be as interesting, but would enforcement be the same way as with a court judgment? You would still need to find the counterparty, find out if they've got assets and try and recover.
Well, it works, I guess, in that sense, it works exactly in the same sort of way. So I think that it's, I think it's a very good question, because, parties to arbitration want to know, I have an award, am I going to be able to enforce that award?
Yeah.
What is the guarantee? But the thing with arbitration is that there are two parties, they have consented to the process right from the outset. They've gone into a contract and they said, look, if we have a dispute, if we have a problem, we'll resolve it through arbitration.
Yeah.
And then presumably the two parties come from jurisdictions which are signatories to the New York Convention, which means that an award is going to be enforceable. But, in those jurisdictions. But the assets might be in a different jurisdiction. Now, that jurisdiction may not be signatory to the New York Convention. Now, that becomes problematic. That becomes complicated. But those are the kind of difficult issues that have to be navigated.
Yeah, sure.
So do you think, and I don't know if you had anything else to say, do you think it's going to be like in the next few years as we see investment in our courts? I know that courts are changing, so they're becoming they're trying to be more attractive to international business. Do you think that this is going to be an area where we're going to see more activity? Do you think it's going to be cheaper in the future for people? Do you think it's something that's where do you think it's going to go for?
Yeah, I was just going to add to that actually. So I think our courts in England at least have a heavy emphasis on resolving disputes out of court. I mean, we're obliged to do that actually as a first step before even going to court. And the judges are really promoting it. They always have, for those who are non-lawyers out there. I know as a statistic, when I was researching mediation, when I was studying it and was being accredited, that in America, which is, they do go to litigation quite often there, the mediation is settling at least 90% of cases there, in commercial cases. So that's a huge amount of cases being settled. So mediation is very prominent in the States. I think it's happening, it's certainly coming across here, it's saving costs for all the parties involved. So I think it's definitely positive. What's really interesting in this is that the role of technology in resolving disputes. So a recent article that I read in the paper said that they're now introducing online dispute resolution, and the courts are actually introducing it themselves. So we're going to have online courts soon, and that's in the pipeline. There's heavy investment poured into it, I think, for good reasons. Of course, the courts are quite strained at the moment with resources, and so it's really good to have online dispute resolution as well as online courts. And I think we're going to be the forefront leader of that, really, because I don't think there's many countries out there that are using technology to their advantage to resolve disputes. So
I think it gives us the other advantage of the UK is that, well, in London especially, we've got financial centre, which hopefully we'll maintain. Next door
Some
to
question marks over
there.
After Brexit.
Next door to real experience and depth of knowledge in the kind of practitioners that you have in London, and I think also the variety of work. So I think but that together with hopefully investment in the way that the court system works will mean that will continue to be for international business and for local business and local businesses. Hopefully the drive in kind of dealing with the costs issues will also mean that people are much more able to use, whether it's the mediation service or the court service.
Yeah, for me it's also like if you if there's a court case and something's ended up in the courts, I always see it as a bit of a stigma, like you're going to have your also like people become rather hostile. I'm going to have my day in court, and it just kind of, it's not very conciliatory. Whereas if you use these other means to try and settle, it just kind of strikes as a lot more friendly
and you also you kind of unravel all these underlying issues that you will never unravel in court, because court's all about what does the law say, what is the facts, and what's the outcome,
the flexibility
based on the law and the
yeah.
facts, and that's all it is. With mediation, you're really unraveling issues, sometimes quite deep issues. And I know that it's been very useful in other areas of law, such as family and things like that, where they're really trying to resolve important parts.
In employment disputes, there is ACAS, the role of ACAS to try and actually resolve the problem before it goes to the tribunal.
Yeah, and that's compulsory now.
Yeah, absolutely, yeah. So you've got ACAS where it is compulsory. And so ACAS, you have somebody... What are they called? I mean, conciliator. And the role of the conciliator is almost like the role of the mediator, to try and get the parties to speak and to try and resolve the dispute before having to go to tribunal, which can be costly.
Absolutely. And also in small claims cases, those that are worth less than £10,000, you have the small claims mediation service, which is offered to you automatically as soon as you lodge a claim for anything that's under £10,000. And I know a lot of my cases have actually settled on that. So
I think the key message from this discussion is that I think our clients, small to medium-sized clients, or even big clients, perhaps should look beyond litigation.
Correct.
And they should think about alternative means of dispute resolution, some of which we've talked about. And obviously they should think about that at this stage when they are entering into drafting their contract. And the thing with, like, when you are you're at the negotiation stage, you are going to enter into a contract, you don't often think about there being a dispute, because
you want it to work. But the strange thing now is, I think this will happen much more, is that if you have a good contract, it helps the relationship, because by and large, I'm sure we all see it. The point at which that relationship breaks down and there isn't anything in writing, that's when it all becomes very expensive and very messy. So I think you're right. I think it's all about...
people don't think about, if they're going to fall out, they think, it's going to work out just fine, which is why it's actually important from the outset to have, proper arbitration clause, mediation clause drafted.
I think it's not just even the way the dispute is going to be resolved, but it's also thinking about all of the kinds of problems that might arise. So when we draft the shareholder agreements, what happens if someone is going to be leaving on bad terms? All those things, whether it's a commercial contract or other kind of contract, you're going through the different scenarios, aren't you? Or what happens if you go bankrupt? What happens if this happens?
You have to be 10 steps ahead.
Which is why you should never download a contract off the
internet.
Don't download the contract off the internet.
Do you know what? Actually, we've had this discussion. I actually think there's a role for it. I genuinely
to download off the internet?
Absolutely, because I think that what it's done is it's given access to legal documents that people just didn't. They were scared by lawyers. I think lawyers now, this is something we should talk about before we go. I think lawyers now are obliged to make sure that they understand the commercial environment in which we're working.
Absolutely.
So I think there's a massive role for these documents. I mean, I always give this example of my sister, who she went online, downloaded some documents. I said, why did you do that? And she said it was available, and she's a professional setting up her own business. Kind of the people we want to be with, but this is how we need to kind of make sure that we're kind of...
I think I agree with that, but I think you have to be very careful which website you go to. I think there's now a role for artificial intelligence out there, and then now the templates that you do get online are becoming a bit more creative. But even if you do get one, if you need us to check it over and review it, we're certainly happy to do that. And, I guess your costs would be lower as a result.
One thing I wanted to speak to you about was your packages, or the kind of things you're trying to do on the arbitration side. Just before we wrap up, it might be helpful for people.
Thanks, Parvani. So I think with arbitration, what it is that the very big firms in the city, it tends to be something that they specialise in, and it sort of has the potential to put clients off, because often you know how they work, charging a lot of the charge-out rates are really high, and they have big teams that work on these things. So what I've done is recently I've published an article on LinkedIn just talking about the different options that we can give our clients. Instead of charging by the hour. We can give fixed fees, so that's one option. If it is a request for arbitration that they need to draft, or a answer and counterclaim, those kind of things, or the full statement of claim or defence and counterclaim, we can draft those on a fixed fee basis. The second thing that we've got as an option for clients is almost as a bolt-on to their existing in-house teams. So if they need, because arbitration is quite a niche area, and if they need someone to come in and kind of assist if they have an arbitration, and whether it's with pre-arbitration advice or with an actual arbitration, that's also something that we can provide. And the third option that we've got, let me just quickly refresh
your memory.
My memory, yeah.
But I think that the reason for that is why I want to talk about that is because one of the things I think we're quite good at doing at London Law Practice is to say, look, we understand the business environment we're in. We understand the kind of role of technology, the role of all of these different types of changes. So it's interesting to know that how you've applied that to the
yeah, absolutely, yeah. So it's actually I called the article kind of innovative approaches to providing arbitration advice. Clients don't have to feel that they have to go to the very big firms. They can come to us, and the expertise that we have is from those firms.
Yeah.
But we are bringing it and making it much more cost effective for our clients.
Yeah.
So we've got the fixed fees that we've got as a bolt-on to in-house teams, and finally co-counselling. So for instance, you might have law firms, that if they have a big case where they need assistance, again, we can easily join their team.
I think it's just being kind of thinking about outside the box about how you can better provide a service. I think it's really interesting. It doesn't, and what you say about the fact that you've got experience in a large corporate practice, and to be able to use that for the benefit of clients is great.
Definitely. Is there any questions? It'd be great to see if people have more questions to ask, and we'd be happy to answer it. We've got Khalid, expert arbitrator here.
Mediation. And litigation.
And litigation.
Absolutely. We've got all three areas.
Yeah, so we cover.
This is a golden opportunity to ask some questions for us, so do bring them in.
And if you want to send them in afterwards, we're very happy to take them and kind of answer your questions after this is finished.
Absolutely.
You can email us at info@londonlawpractice.com and just ask for Khalid or Kishan or I, or call us up. You've got our details on the Facebook London Law Practice page.
And also our website.
And our website.
Yes.
Mustn't forget that.
We even have the website.
And also, feel free to join our Facebook page, like it. That'd be good to kind of share it around as well, to people get more of the legal news update. Hopefully, episode 3 coming soon.
Absolutely.
Yeah.
So we've got the election coming up. Although things have kind of stopped because of the Manchester event. And if we have clients there, we hope that everyone's
we hope everyone's
safe.
okay and safe. Yeah, it's really sad to hear that.
Yeah, no, it's the events of the last few days have been particularly tragic, and it's what we found is that it's we obviously work in an environment, and people are still continuing to do business and so on and so forth. But we've had some big events over the last few months, and so.
So the next one that we have is going to be after the election. So
the aftermath.
The aftermath. We'll hopefully be able to speak about what kind of laws, new legislation that the new government will be
implementing, and the kind of that would be great. Actually, we can do that.
We can talk about that and the impact that it will have on our clients potentially.
Okay, so what we're going to do is probably wind this up shortly, but there will be a blog post about the things we've covered today, so please like and share that too. Please join us for the next episode in a month or so's time.
Yeah.
And so then, thank you. Bye from me.
Yeah, bye from myself.
Bye. Take care.
Take care. Thank you for joining us, and thank you for listening.